Want to know what Europe does for you? Welcome to the European Parliamentary Research Service podcast on representative actions to protect the interests of consumers.
European consumers may one day be able to get together to launch a collective action in court if they feel their rights have been violated.
It's part of the New Deal for Consumers package of the European Commission, which aims to strengthen the rights and protection of consumers across the EU. Want to know more? Stay with us.
In April 2018, the Commission took an important step to further improve the protection of European consumers.
Under the New Deal for Consumers, it could become possible for a qualified entity, such as a consumer organisation, to seek redress, such as compensation, replacement or repair, on behalf of a group of consumers at European level that have been harmed by an illegal commercial practice.
In some member states, it is already possible for consumers to launch collective actions in the courts, but there is currently no uniform system of collective redress applicable to all EU countries.
The proposal came in the wake of the 2015 Volkswagen emissions scandal and the 2017 extensive cancellation of Ryanair flights, which showed that even when faced with mass harm situations, it was difficult for EU consumers to seek repairs or compensation.
The Commission had also long concluded that the patchwork of different national laws and procedures created a sort of justice gap, meaning that consumers had different rights depending on where they lived.
So what kind of rights are we talking about?
Well, when faced with infringements of consumer law, consumers may now get redress in a number of ways, but these vary between member states. Individual consumers can complain directly to the seller, use official dispute resolution mechanisms, or seek help from European consumer centres. They can also file a lawsuit in court, although this can be very costly, or use the European small claims procedure for claims of under €5,000.
Collectively, they can also benefit from public enforcement of consumer law, and in the case of representative actions where the lawsuit is initiated in the name of the affected consumers but not by the consumers themselves, member states are currently required to have such procedures only for stopping or prohibiting infringing practices, but not for obtaining consumer redress.
And only qualified entities with a legitimate interest in the protection of a collective interest of consumers, such as consumer associations or an ombudsman, can initiate proceedings seeking an injunction.
That's right. Now, both the European Commission and the European Parliament have long been calling for EU consumers to have an effective system for collective redress at their disposal. So what changes could the proposal bring? Stay with us.
Well, let's imagine a Dieselgate-type scenario. With the new rules, victims of unfair commercial practices, such as misleading advertising by car manufacturers, which does not comply with EU laws for type approval of vehicles or environment legislation, would be able to obtain remedies collectively through a representative action, which was not possible until now.
But there could be many other changes. For example, the scope of the new rules, which could be very wide and cover all infringements that harm the collective interests of consumers in sectors such as financial services, energy, telecommunications, health, or the environment.
As with the current rules, under this proposal, only qualified entities would be able to bring representative actions on behalf of consumers, and they would be allowed to start actions in any EU member state. Those entities' sources of funding would also need to be fully transparent and clear from the beginning to avoid any conflict of interest.
Qualified entities would be able to seek injunctive redress measures and also compensation. The court's final decision would have effect in all EU member states, and companies which don't comply with it may face serious fines.
So what do stakeholders think about the proposed new rules?
Well, in general, consumer organisations welcome them, but would have liked the new rules to protect consumer interests against violations of all EU law, and not just consumer law, while the business community is worried about insufficient safeguards against abusive litigation.
In its first vote on the package in March 2019, the European Parliament added safeguards to protect companies against abusive litigation and deleted a precondition that consumers should wait for a final injunction order establishing the existence of an infringement before being allowed to demand compensation.
Negotiations between member states in the Council are still ongoing. We'll have to wait and see what happens. If a deal can be agreed on the proposal, it will be a very welcome step towards granting European consumers better protection in today's borderless economies.
You're listening to the European Parliamentary Research Service podcasts.